The great majority of court decisions have correctly ruled on how to interpret the meaning of constitutional provisions. And our founding fathers made clear statements on this point. I will quote from some statements in Corpus Juris Secundum on constitutional law, which is a law book that contains collections of all decisions by courts, state and federal, in this country since it started. And I quote, "Where a constitutional provision is comprehensive in scope and leaves no room for interpretation, a court is without power to amend, add to, or detract from a constitutional provision, or to create exceptions thereto by implication." End quote. Another quote, "When interpreting constitutional provisions, the courts look first to the plain language of the text and will accord it its reasonable interpretation." End quote. Another quote, "Unless to do so would contravene the manifest intention of the framers, the language of a constitutional provision should be construed as it is written, and the words employed should be given their natural and obvious significance, having due regard from the rules of grammar and punctuation." End quote. Another quote, "The basic principle of the American constitutional system is that all political power is inherent in the people, and that this inherent power is exercised by the people under a constitution adopted by them." End quote. Now, Thomas Jefferson said, "On every question of construction, carry ourselves back to a time when the Constitution was adopted. Recollect the spirit manifested in the debates, and instead of trying what meaning can be squeezed out of the text or invented against it, conform to the probable one in which it was passed." End quote. James Madison said, "I entirely concur in the propriety of resorting to the sense in which the Constitution was accepted and ratified by the nation. In that sense alone, it is the legitimate Constitution." George Washington said, "If in the opinion of the people, the distribution or the modification of the constitutional powers be in any particular wrong, let it be corrected by an amendment in the way that the Constitution designates. But let there be no change by usurpation, for though this in one instance may be the instrument of good, it is the customary weapon by which free governments are destroyed." In spite of all this, there have been some liberal judges in recent years who have changed the original meaning of the Constitution to promote the liberal agenda. The most famous of these rulings is Roe versus Wade, in which the United States Supreme Court held that the Constitution prohibits a state from passing laws making abortions illegal. At that time, 33 states had passed and kept in effect state laws prohibiting abortions in those states, and 17 states had made abortions legal. There are no words in the Constitution or any amendment that give to the federal government or the federal Supreme Court any right to make that ruling. The word abortion is not mentioned in the Constitution.